morning, everybody. Thank you for coming in with such energy, and I can see all of you are enjoying yourselves at the tables. We'll get going now. If anybody has any spare seats left, if you can raise your hand, and we can try to fill in some of the extras that are in the hall waiting. Okay? Looks like we could have a good dozen here. So if we can give word to Pat on that, that'd be great. Thank you all for your patience here this morning. My name is Patrick Baker. I'm the Director of Labor Relations for the Construction Association of Michigan. And I want to welcome you here on behalf of CAM and on behalf of the Building Trades, the Michigan Building Trades Council. Here we have Pat Devlin. Thank you, Pat, for partnering here with CAM. As well, we have a sponsorship, major sponsorship from Must. We have the Wendy Herring could not make it today, but Wendy Richardson is here on behalf of Must. So thank you, Wendy, for being here. Just a couple of housekeeping notes. The restrooms, if you need them, will be down the hall that you came to the entrance and make an immediate left. And a short ways down on your right, you'll see the men's room, and I think a little further will be the ladies' room. Also, there is beverages. There's some juice available. If you'd like to have some, just raise your hand, and the wait staff here is, as you can see, waiting in the wings here to assist us with that. So we'll have two parts. We're going to have our breakfast here as we get going, and I want to just mention at the outset that these are tough times. And you all know it. These are tough times, Michiganders. We all know it. There isn't a lot of light at the end of the tunnel that we're all seeing. We're all coming here together at a time, I think, of the greatest divisiveness that I've ever seen in my lifetime, and probably yours. That's why, and if I could borrow a phrase, that we must unite together as Michiganders, as fellow working people, working to build buildings, build roads, even, yes, demolish some buildings, make way for better buildings, and better futures for future generations. So if I could borrow that phrase, must, management, unions, standing and serving together, I think it's very apropos that we are gathered here together, management, unions, associations, this whole industry, to consider how shall we face the challenges now in front of us all with this new right to work, and what can be known about the impact that this law will have upon us and upon our collective bargaining agreements and the ability that we go about making not only livelihoods for ourselves and our families, for our companies, but also building a future for all of Michigan. So I welcome you all, and I think that it's appropriate at this time to stand and make a pledge of unity together in that old tradition, if we could. Let's stand as many are standing for us in the line of fire, men and women in the armed services, who are pledging their lives, their honor, their fortunes, and pledge allegiance to that flag and to our republic. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And before we begin, I'd like to, if I could, indulge you for a moment for a prayer. In these difficult times, I think it's important to call upon wisdom from above, His grace. So let us pray. Father, we pray for wisdom and grace to guide our morning together as we endeavor to seek together a better understanding through the midst of these challenges we face, that we may then come together better equipped with minds open and hearts open and courage to implement solutions creatively that will bear fruit for our respective interests and for our whole industry for years to come. Father, we ask you to bless all of us here gathered this morning. Bless this meal that's been prepared for us. Bless those who have labored on our behalf, from the fields, from the trucks that delivered, to the supermarkets, to the cooks, and to our wait staff here gathered. For these blessings, for the gifts that we're about to receive from thy goodness, O God, we give you thanks. Amen. So, if I could, one last thing. There are note cards. Hopefully you can see them around your tables. If you need some, please raise your hands. that I want you to please, as many of you as you can, fill in your questions. We do have an organized format, a PowerPoint that's going to kind of set the table, if I may, of the basics that the lawyers understand of the machinations of this new right-to-work law. But it's your questions that we want up here as well as soon as possible. So if you can fill those out right away, some of our staff will be going around to gather them up here right at the beginning, so we can have a nice handy stack and try to pull out duplicates. Again, enjoy your breakfast. We'll be back together again in 15 or 20 minutes. Thank you. Well, I hope you're all enjoying your breakfast there. If you haven't yet finished, go ahead and continue. Again, there is juice beverage service available too if you like. That's one of the helpful servers there. And if we can, I'd really like, if we could, to express our gratitude to what a wonderful job that the Vista Tech facility has done for us this morning. I want to note, too, for this room, you may be of interest, it's unionized labor in here. And we really appreciate all the great work that Vista Tech has done. We want to thank the wait staff, the cooks. I think the food was just wonderful. So let's give a round of applause. Before we get started, or as we get started, I'd like to also note Vista Tech is here with the Schoolcraft College. And we have to have the good fortune of having a new trustee, Mr. Terry Gilligan. Are you in our audience today? Could you please stand up and be acknowledged? Congratulations on your election. Should be very proud to serve on this board. Yes, it is. Well, I'd also like to acknowledge again our partners this morning, Michigan Building Trades Council, Pat and Devlin. Thank you, Pat, for your generous support. And Wendy Richardson with us. Thank you. For our table sponsors around, if you look at your table there, you'll see the sponsors of your tables. We have Architectural Contractors Trades Association, ACT. We have BAC Local 1. We have the CCA, Carpenter Contractors Association. Great Lakes Fabricators Directors Association. The International UPAT, International Union Painters and Allied Trades. MCA Detroit. SMATNA, Southeast Michigan Roofing Contractors Association, and Urban's Petition. Let's give them all a good round of applause. Next, I'd like to acknowledge here with us CAM's new and current board chairman serving, Mr. Greg Andrzejewski. If you'd stand and be acknowledged. Mr. Andrzejewski was just placed on the board as our chairman here after, I think we're serving now in our 127th year of CAM service. So you're in a storied list of board chairmen. We have other board chairmen, past board chairmen here among us. Bruce Pregler, if you'd stand and be acknowledged, we appreciate you among us. Pregler, Richard Faka. Also, Steve Daly is here among us. Steve, can stand and be acknowledged. Steve Daly comes from the Daly Company. Do we have any other past board chairman of CAM in the room here? Is Glenn Parvin in the room? Glenn, thank you for being here. Any others that stand and be acknowledged? So, and we also have most of our board of directors currently serving. If you could all stand and be acknowledged, I appreciate that very much. CAM's very own president, Kevin Cole. Kevin, if you'll stand and be acknowledged. Thank you. And finally, I'd like to personally thank CAM's staff that's worked so hard in getting this facility together, getting all of our materials together. And among us today, we have Pat Dufresne, Matt Osterman, Greg Montowski, Marcy Christian, and I appreciate all the work they've done. Greg also has come with materials for our CAM marketing, from our CAM marketing and sales staff. He'll be at the back of the table there if you have any questions about becoming a member of CAM. So first, how we're going to proceed today is we have an esteemed panel of guests here, and I'd like to first introduce our moderator today. And I'd like to make clear and note that by the order of his boss, the Federal Office of Mediation and Conciliation has permitted Mr. Jim Statham, a storied mediator here, to be with us to moderate our program. And by order of the boss, he's not contributing any of his opinions, but he'll be fielding the softballs and hardballs and pitching them over to the esteemed panel here. So if I could, I'd like to introduce first Mr. Statham. So Mr. Statham comes to us after over nearly 40 years serving on the Federal Office of Mediation and Conciliation, an independent agency of the United States government where he mediates labor disputes, employment discrimination cases, and various civil actions. He frequently conducts training sessions for labor and management, both in areas such as communication, negotiation, interest-based bargaining, and cultural diversity, and he also facilitates cooperative labor management committees. Mr. Statham is an adjunct or formerly adjunct professor of management and union relations at the University of Michigan School of Business. In addition, he's taught many dispute resolution classes at Wayne State University, as well as a negotiation seminar for lawyers at Wayne State University Law School. So would you please welcome Mr. Statham here, as he'll be the moderator for us. He'll keep things going. I'm going to hand off the program to Mr. Statham. So thank you for acknowledging it. Again, please, I will have staff going around to pick up question cards immediately. For those, please raise your hands if you would, and we'll get those questions going. Thank you.
We got a lot of information to present to you in a short period of time. So what we're going to do is, our first speaker is going to be Don Scharg from Bodman, Longley, and specializing in labor law. I've known Don for probably 30 years. He's one of the leading management labor lawyers in town. And after Don's presentation, we're going to have John Tesija, who is a partner, the senior partner in Novara and Tesija. And John specializes in employment benefits law, and he represents pension and other fringe benefit plans throughout the country. And he's going to talk about the ramifications that this new law has on pensions. And following that, we're going to have Pat Devlin, who is Secretary-Treasurer of the Michigan Building Trades Council, and has been since August 2005, going to tell us about not only how the building trades feel about what the effect of this law is going to be, but he's also going to tell us about what effect this right-to-work law has had on unions in construction unions in other states, problems they've had. And because we got such a short period of time to give you this information, what we want to do is hold questions to the end. Now, everybody has cards and pens at the table. What we'd like to do is have every one of you think of one question, just one, you want to answer, and then we'll collect them, and then we'll deal with those when the panel presentation is finished. All right? And I won't take any more of your time. First speaker is Don Scharg.
Thank you, Jim, and welcome. Hello to everybody. First of all, thank Patrick and his staff. This is a great event, and I know you put a lot of hard work into it. It's great. I'm going to diffuse everything. My job is to give you an overview of the law, and I'm going to diffuse everything, and I'm going to preempt the questions, because I'm going to answer the most burning question for all the employers and the contractors in the room. Is there any financial benefit to the Right to Work Act, to the Freedom to Work Act for the contractors? The answer is absolutely not. So I'm going to leave that to you right now. You might as well get up and go, because there's no financial benefit for anybody in this room from this law. So let's get started. Okay, we start with the National Labor Relations Act, and specifically Section 883 of the National Labor Relations Act provides the genesis for the Union Security Clause. And everybody here should know what a Union Security Clause is. That's a portion in the labor contract that says that employees and new hires have to become union members and pay dues in order to continue their employment. And we have a sample Union Security Clause right here from a CAMP contract. And it says that employees, as a condition of employment, that's legal jargon for if you don't pay dues, you're going to be terminated. And that has its genesis in the Section 883 of the National Labor Relations Act. And typically, if an employee refuses to pay dues, The unions will send out a notice, maybe 2 or 3 notices, and then even if this employee is the best employee in the world, even if the employee was the first one hired 25 years ago, if that employee refuses to pay dues to the union under a union security clause, that employee will be terminated. Then we have exceptions in the law for religious reasons. If an employee says, it's against my religion, it's a tenet of my religion not to pay dues to an organization and not to pay dues to the union, the law provides that the employee can pay an equal amount to a non-religious, non-labor charity. I've been doing this for 35 years. John's been doing it for, I don't think it's as old as I am. Doesn't look as old as I am. Jim's been around for a while. I have never had an employee, I've never had a question from an employer about this subject. So I'm not sure. There must be people out there who take this exemption, but it's not very often. I've never seen it. Okay. Then we got to the point where employees said, yeah, I understand I have to pay dues to the union, but I don't want to be a union member. And so the question went up to the NLRB and the courts, what does it mean to be a union member under a union security provision? And they determined that a union member only means, at its very core, being a financial member. That if the employee chooses not to sign a card to the union, not to go to the meetings, not to in this situation, not to get strike pay if there was a strike, that employee could just pay the amount of the union dues and fulfill the obligations of being a union member under a union security provision under Section 83. And then in the 80s, there was a guy by the name of Mr. Beck who said, not only do I not want to be a union member, but I don't think I should pay the full union dues because some of the union money goes to conventions, goes to Christmas parties, goes to other type of activities that don't benefit me. And the Supreme Court of the United States, in the case of Beck versus communication workers, agreed and said employees who choose not to be full union members only have to pay dues equal to the amount of the benefit that they're getting. So unions engage in organizational activities, that benefits all employees because the more employers that are unionized, it helps in collective bargaining. Unions engage in collective bargaining, that helps everybody. Okay? So they have to pay for that. There was just a case in front of the NLRB about lobbying efforts. The employees said, I don't want to have to pay for the union lobbying efforts because I don't agree with their lobbying subjects. And the NLRB, this NLRB, said, we agree that with the unions that lobbying efforts are related to union activities that benefit everybody. And so the employees have to contribute toward those lobbying activities. And what does it mean, practically speaking? It means that for some unions, employees who choose this method, and again, very few employees choose this method. I've only probably had a handful over the course of over the years. They may get a reduction in union dues from 10 to 15, 20%. And that brings us to the Freedom to Work Act, which also has its genesis in the National Labor Relations Act, in Section 14B of the National Labor Relations Act, which was passed in the 40s. It provides that states and territories, and it also includes Indian reservations, can choose to not enforce union security provisions. So even though there was a union security provision that says that the employees have to be union members or have to pay dues, if the state, now Michigan has done this, if the state says we're going to have a right to work state, that we're not going to require employees to pay dues, then even though you had a union security provision, the employees can choose not to be union members and not pay dues. They can't be forced to pay for union security or to join the union. And so it's going to be their complete free choice, whatever free choice means. And we see that there's now, with Michigan, there's 24 states that have gone to right to work status, and we have a map. Typically it was the South and the West that was in right to work status. Now we have Indiana from a couple years ago, and now Michigan, and according to some of the articles that I've read, that Ohio is now talking about, because it will be a question if Ohio sees that Michigan is attracting industry because of this quote right to work status, they can perceive that's the reason why companies are moving to Michigan instead of Ohio. You see that Ohio will start talking about it. Will they be able to do it? Who knows? But it will be on subject on the table. Why is right to work important? First of all, right to work means union dues, translates right into union dues, because that's what it's all about. It means that, as I said, employees don't have to pay union dues. And the union dues, of course, are the revenue stream for the unions. So, and you see that from this is the latest statistics, I think it was 6.6% of the it should be the private sector, non-public sector labor force is unionized. And as that number reduces, as it has been, that's less dues for the unions, and if there's employees who are within that unionized number who are not paying dues, that's less of a revenue stream for the unions. And the governor says right to work is important because he thinks it's going to attract business to Michigan. And we see that, according to Forbes, 7 of the top states that are having economic gains are right to work states. Is there a connection? That's debatable. I don't know. So let's get to the operative language and wording of the Right to Work Act, the Freedom to Work Act. Basically, it says that an employee does not have to become a union member and does not have to pay dues. So we don't even have the core financial membership anymore. An employee can choose to say, I'm not going to be a union member, I'm not going to pay dues to the union, I'm not going to pay initiation fees, fines, charges, whatever. It prohibits the use of intimidation or coercion to get employees, to force employees to join the union or pay dues or not pay dues. So it's on the employer and on the union. The union can't force employees to coerce employees or intimidate employees to join the union and pay dues. And likewise, the employer cannot engage in those activities to encourage the employee to, or force the employee to pay dues. Or on the flip side, the employer cannot coerce an employee, intimidate an employee to not pay dues. You can't, the employer cannot go to an employee and say, you have the right not to join the union. I'm telling you not to join the union, not to pay dues. And any violations are subject to a penalty of $500, and there's a civil action that an employee who feels that they're being intimidated or coerced can bring. And this law has 3 magic words that are music to every lawyer's ears, and attorney fees. So an employee who believes that they are being coerced one way or another from the employer running the union, and if an employee is terminated by an employer wrongfully for not paying dues, that employee can go to an attorney and sue. And we see Sam Bernstein is now doing the Social Security. I think business is tough for Sam Bernstein because he's now he's advertising Social Security cases. So I think on the commercials you might even have right to work cases down the road. And who's covered? All employees, all private sector employees are covered except for those in the airline industry, the railroad industry, because there's nothing in the Railroad Labor Act which is a mirror to Section 14B of the National Labor Relations Act, which allows the right to work actions. So since the Railroad Labor Act doesn't provide it, doesn't allow it, the state excluded those employees. Now, something that the state legislators did, which was very smart, is they excluded the guys with guns from this act. So the police, the state police, and the firefighters are excluded from right to work. So they still can be required to pay dues. And the UAW is challenging whether the state workers who are under civil service are within the Right to Work Act also. Yeah, I just read something about that. That case was refiled in the Court of Appeals. The effective date. When the law came out, we weren't sure when the effective date was because there was no effective date in the statute. And there's
legislative procedure that it's 90 days after the closing of the session. When was the closing of the session? I think we all agree now that the law takes effect on March 28, 2013. And this is the key for everybody. It applies to contracts, agreements, understandings, and practices that are that go into effect after March 28th. So the key is, if you have a deal that's done before March 28th, 2013, you can have a union security provision which goes past March 13th, March 8th, 2013. Is everybody here familiar with MITA, Michigan Infrastructure and Transportation Association? They're the road builders, they're the underground guys. They signed a contract in December, right after this all was passed, with the laborers, extending out the contract to 2013.
10 years.
10 years. 2023. 10 years, yes. I'm also not a doctor because I'm not good at math. So they have a 10-year deal with the laborers, and that seems to set some of the patterns and standards, because during that 10 years, since that contract is going into effect before March 28, 2013, then for that 10-year period, the unions and the employer can enforce the union security provision and keep that dues stream going without any challenge. Now, I was talking with John and Jim, and we have a question. I don't think we can even answer it today with all the lawyers in the room. Is what is an understanding or a practice? We know what it is in labor law terms, but in terms of a provision that affects union security, we can't think of anything that applies to that. In fact, if you look at Section 883 of the Act, National Regulations Act, it conditions having union security provision on having an agreement, not on a practice, not on an understanding, but on an agreement. So we'll have to wait and find out what these words mean. And we're sort of concerned about how it's going to be interpreted, not by the National Labor Relations Act or board, but by state court judges. And the flip side is that if there's an agreement that goes into effect after March 28, 2013, that agreement cannot have an enforceable union security clause. And so if you don't get the deal done before March 28, 2013, when your current contract expires, then you'll be in the Right to Work Act mode, where employees can choose to decide whether to pay union dues or not. Okay. Now let's say March 28th comes and goes and you don't have a deal. It's not the end of the world, because the employees don't magically have a right, or the union dues don't magically stop because March 28th has passed. The employees have to take action to effectuate their Right to Work Act rights. In fact, first of all, they can't do anything until after the contract expires. So if you have a contract now that goes until, let's say, 2015, that contract is full in effect, and the Right to Work Act provision, the union security provisions are still in effect. So let's say your contract expires on April 1st. The Right to Work Act provisions go into effect, and then the employee has to send a letter. To the union saying, I don't want to be a union member, I don't want to pay dues. And they also have to terminate their checkoff, because if they don't terminate their checkoff, that checkoff agreement is a separate agreement, and it continues to require the deduction of dues from their paychecks to the union. So it's a double whammy there that they have to do. And there's no obligation under the statute for employers or for unions to tell the employees what their rights are under the Right to Work Act. So basically, it's up to, and there are lots of ways for the employees to find out. There's the internet, people will be talking, there's be newspapers, but there's no obligation for employers or unions to issue any type of notice to the employees saying, it's now March 29th or March 28th, these are your rights. And most of the
checkoff provisions have very limited periods of time when they can be terminated. And there's no obligation to tell the employees what those periods of times are. So if the employees don't give any notice, there's no cessation of the dues stream. Here's the rub that the unions always complain about. And they complain that we may have some free riders. And that's the definition of free rider is someone who isn't paying union dues, and they still are under the contract. And the unions don't represent, they represent their members. They have members, but when the union has a labor contract with a company or with an association, the union represents the unit in the agreement, not the members of the union, but the unit people, unit employees. So there's an obligation, continuing obligation, even if the Right to Work Act goes into effect, and even if employees choose, we get to the time period where they can choose not to pay union dues, the union still has to represent the employees, the unionized employees, the members, and the non-members in the unit. They can't discriminate between the union members and the non-union members within the unit. They still have to represent them. They'll represent them in collective bargaining. They have to represent them in the grievance procedure. Now, the grievance procedure is open to both members and non-members. It's open to employees. Now, unions will have an obligation. They cannot engage in arbitrary, capricious, or bad faith conduct. But I gotta believe that when a non-union employee, non-member employee files a grievance, it's going to be very looked at, kicked around, and jabbed, and looked for any exception why this is different from all the other grievances that have been filed by union members. So there is some room to review grievances and decide what you're going to have to take and not take to arbitration. You just got to be careful, because if you choose to cut that line very close, even if you don't cut it close, and employees think that they're being discriminated against because they're being not paying union dues, of course they have a right to file a lawsuit claiming failure to provide representation. And that line of cases has basically dried up over the last 15, 20 years. It's been a long time since I did see the duty of fair rep case come along. And they're very hard to win for the employee. And this may open up the flood doors again for employees who say, I filed a grievance, I'm not a union member, but I think it should have been taken to arbitration. So the key is you got to be careful. Act defensively. Now, we also have some erroneous assumptions based upon the right to work law, and I think I diffused the major one at the very beginning, that there's no incentive, financial benefit for employers. This is only dealing with union dues. So when you have that line in the benefit column of the contracts and it says union dues, the employer never sees that money. Right now it goes to the union. When the Right to Work Act goes to effect, and the employee sends the letter terminating their membership, sends the letter terminating the checkoff, that money will go into the employee's paycheck. The employer will never see it, it just goes into the employee's paycheck. One question I always get, and I think I get it 4 or 5 times when I'm doing a seminar, is do we have to pay fringe benefit under the contract on people who have chosen not to be members? And the answer is, if membership in the union or non-membership in the union is irrelevant to the obligations that you have, the contractors have in the labor contract. If the labor contract says you have to pay into the fringe benefit funds, you pay into the pension fund, you pay into the apprenticeship fund, you pay into must, that doesn't change whether the person is a union member or not union member. For all hours, your obligation as a contractor is to pay those fringe benefits for all hours that are worked as defined by the labor contract, whether it's straight time or overtime, whatever the contract says. Your obligation does not change. So even though a person chooses not to be a union member and chooses not to pay dues, you are still paying full contributions based upon that employee's hours. And we might even get another question about that, but nothing changes for the employers. It's just where you're sending the dues money if they choose not to pay their union dues. And there's some employers probably not in this room, but employers say, well, if employees are choosing not to pay union dues, does that mean that they don't support the union? And then I can get out of having the union? Absolutely not. There's no, according to the law, according to the National Labor Relations Board, there's no correlation between not paying union dues and not supporting the union. The employee can say, yes, I support the union, I think it's great, I think they're doing a great thing, but I don't want to pay my union dues. And there's no assumptions that can be made. Even if 100% of the employees choose not to pay union dues, the presumption is that all support the union. So don't do anything crazy about when you see that employees are choosing not to pay the union dues. And then there's the biggest hammer of all that John is going to talk about, which is withdrawal liability. That if there is if the employees choose not to pay union dues, and it turns out that they either decertify the union or the union disclaims interest, and so we're not making any money off of this deal, we don't want to represent you, that triggers withdrawal liability, which could be hundreds of thousands or millions of dollars for a contractor they would have to pay because they're no longer a signatory to the labor contract. And John's going to get into more detail about that. And we get questions about, and before I said there was no obligation to give notices by either the union or the employer to the employees. So that leads to the question of, can we? And the National Labor Relations Act says, and it's been interpreted to say that employers can communicate with the employees if they do so on a neutral basis and only give factual information and don't tell the employees what to do. So if you want to tell the employees that, yes, the Right to Work Act has taken effect, and you have these rights, you can say you have the right not to pay dues if there was an implementation. We're not telling you what to do, we're just telling you what your rights are, and whatever you do is your free choice. Or you can say, the Right to Work has taken effect, we believe that it's important that all the employees remain union members, because we need strong unions to keep this industry going. We can't tell you what to do, it's your choice, but we're just telling you what our feelings are. That would be okay also. And I found a General Counsel memorandum from the National Labor Relations Board from, I think it was 2003, which was a Bush board. And it said that the employers and unions can have a contractual provision in a right-to-work state that says that the employer can encourage employees to join the union and can even offer to have the union steward or union business agent meet for 5 or 10 minutes with the employee so that the business agent can encourage the employee, tell the employee all the benefits of joining the union. That's something to think about also. Here's another map. It shows the right-to-work states. This is before Michigan became a right-to-work state. You see that except for basically Nevada and Indiana, most of the states that become that are right-to-work states have reduced union membership or lower union membership. I haven't seen any statistics, and maybe John or Pat has statistics about whether right-to-work has affected union membership. I saw an article about Oklahoma that said that maybe 6% decided not to join the union. I have to believe in the construction trades, that number is going to be very, very low. I think you're going to have, once in a while, you got somebody like this Mr. Beck who took a case all the way up to the Supreme Court. But most of the time, you're going to have employees who are working closely together, who are going to the trades together, who depend on each other. And the employee does not want to be the one who's identified as not paying union dues. If they're in a trench and they have to depend on the guys on top to get them out if there's a problem, they don't want to be the one that didn't pay their union dues. So I think, I don't think we'll have a big effect. Not that anybody would do anything, but it's just that perception. I don't think that'll have an effect on the building trades. Pat will speak to that too, but my guess is it will not. There's current legal challenges to the law. You read in the newspapers. I won't bore you with that. Issues to be resolved. Will employees decide, if given a chance, in 2023 or whatever, not to pay union dues, we don't know. Will it have an effect on union membership? We don't know the answer to that one too. I do know that it's incumbent upon the unions to work harder to get union members and to build up the industry. I was at the NLRB seminar a couple years ago, and I got booed because I told a story. This was when the Employee Free Choice Act was being debated. And I hope I don't offend anybody here. But when my kids were small, there was a story, a book by Shel Silverstein, he had a poem called Lazy Jane. It was a girl laying down, looking at the sky, and it said, lazy, lazy, lazy Jane, she wants to drink the water, and she waits and waits and waits and waits and waits for it to rain. So I got into the NLRB, I represent a lot of employers. I said, the 2009 version is lazy, lazy, lazy union wants members, and it waits and waits and waits and waits for them to join. You guys got to get out there and hustle and work hard to get the companies signed up, to get the industry going. The union contractors are really hurt by the non-union competition, and it's incumbent upon the unions to help out there. For those unions that don't have extensions yet, they're engaged in negotiations to extend. You know that's going to happen. What's going to happen after March 28th for new signatories? So I'm telling you to go out and hustle and get new companies signed up. Well, those members, after March 28th, those employees are going to be under the Right to Work Act, even though your contract, let's say MITRE or CAM, is going to be in effect before March 28th. That's going to be a new contract for that company, that new signatory company. And so you're going to have to work hard to get those new union members to sign up and pay union dues, because those guys are going to have a choice. I mean, they're going to go from a situation where they're not paying union dues to paying union dues. So it's going to be a hard task for you, but you've got to go out and do it. Talked about withdrawal liability. And will companies relocate to Michigan? I don't know. Maybe the governor knows, but I don't know. We hope so. We hope that we need companies in Michigan, but who knows what's going to happen. Thank you very much. Let me turn it over to John.
Thank you. Again, my name is John Tesija. In the past, Don and I have sparred quite a bit of a number of issues, and if you told me that Don Scharg told you something, I'm probably going to tell you that he's full of, you know what. But on right to work, I think he's spot on. We basically agree. If you look at your handout, my summary memo there is pretty much a mirror image of what he's got there. We're all struggling basically with this new statute and trying to make sense of it. I'm going to touch on withdrawal liability, as Don indicated, and a little bit on fringe benefits. But I do want to touch on a couple other side issues. One is this grandfather clause. Don mentioned March 28th. We're using really March 27th as the cutoff. You got to get your contracts basically in place by March 27th. That's not just a union-only issue. I think we got to make that clear. This is kind of an employer issue as well. There's some reasons why that's an employer issue, and those are spelled out, and I will go in detail in your book. It's page 17 of your book. But basically, if you have a mixed bargaining unit with members and non-members, you're going to have some productivity issues. You've got, obviously the withdrawal liability issue that I touched on. And then at the end of the day, if the union is weakened, if the union is not doing what it's supposed to be doing, then it's not going to go out there, recover the market for you, try to get the jobs that you guys need to bid on, and so forth and so on. So there's a number of reasons why it's good to get these contracts done before March 27th, or 28th, according to Don's book. The one thing I want to touch on also is the fact that none of us up here can tell you with certainty that if you do all those things that you're going to be ironclad protected. Really, we just don't know. I think that was pretty clear that they use these loosey-goosey terms like understandings and practices, and what the hell that is. We all know what a contract and an agreement is. but practice and understanding could be anything. So my advice to you is when you get these contracts done, don't tinker with them. Try to do the least amount of tinkering going forward. One of the things that we propose in our handout is if you're going to have openers in the future, keep them to limited openers. Keep them to economic terms. So don't go try to renegotiate the contract, because I think that's apt to trigger the statute. The one thing that we have going for us in Michigan, that Indiana was the state that adopted this law before us. Indiana, their grandfather clause triggered it if you modified your contract. So any tinkering with the agreement would have triggered the statute. That's not the case in Michigan. So you do have some leeway, but again, my advice is the less is better. And of course, Indiana made it criminal. It's a criminal violation. Michigan didn't go that far. So at the end of the day, there are reasons, both union and management, why you want to get these contracts extended before March 28th or by March 27th. And one of the biggies is this withdrawal liability issue. In addition to that, fringe benefits also, of course, is a factor, and I think Don touched on that as well. And that is, so we're clear that even if you have a number of men in a bargaining unit, say 10-man bargaining unit, say 5 of them bail out and are not paying union dues, you as a contractor still have to pay fringe benefits, the full package on behalf of all 10. Not just the 5 union guys, but all 10. That's the key. That's why there's no benefit, economic benefit to the contractor in this statute. Now, what happens with pension? And this is a big issue. How does the pension come in, and how does right to work affect the pension plan? Well, this all goes back to the withdrawal liability statute that was adopted in 1982 during that recession. Remember that recession? A little easier than this one, huh? 1982, Congress passed a law that basically, they looked around, they saw all these underfunded pension plans. They said, look, we don't want to give incentives to contractors to bail out on the pension plan. We want to keep them in. We want them to continue contributing. So they adopted this thing called withdrawal liability. And it's very technical. It takes up about 40, 50 pages of a statute. It has formulas and rules. I'm going to try to distill it down to its essence here, and especially since this is all construction industry. I'm assuming most of you guys, if not all, are in the construction industry, and they have special rules for construction industry. But the bottom line is this, that if you have a underfunded, defined benefit pension plan, there's all kinds of pension plans out there, but it has to be a defined benefit, not a 401k, not a defined contribution individual account plan. It's a pool plan. Employers contribute into a pool plan. That plan then promises future benefits to participants based on years of service, hours of work, dollars contributed. There's all kinds of formulas, but it's really a lifetime benefit based on some formula that's paid out of the pool. And I would hazard a guess that everybody in this room is somehow related to a underfunded pension plan. I don't know one plan in town that's 100% funded, because the construction industry has taken a huge hit with the recession. The markets, investment markets, have been haywire, so the returns have been up and down, mostly down, unfortunately. As a result, you've got a whole bunch of underfunded pension plans out there. And the general rule, the gist of the rule is that the actuary, the pension fund actuary, calculates the amount of the underfunded pie. Let's call it basically, think of it as a funding pie, and the more underfunded you are as a pension plan, the bigger the pie is. Then, if you pull out, a slice of that pie gets allocated to the withdrawing contractor. And the size of that slice depends on how big that contractor is or was, and how long he was in the plan. So the bigger the contractor, measured usually by contributions, but it can be measured by other methods. So the bigger the contractor, measured by contributions, and the longer you're in the plan, the bigger slice of that underfunding pie you're going to get. And the rules look back 20 years, basically. So it's kind of a statute with a long, long memory. At the end of the day, in order for you to be assessed withdrawal liability, you've got to pull out of an underfunded plan and go non-union. If you simply shut down your company or you sell your company, again, I don't want to complicate it with side rules, but if you simply go out of business, you will not be assessed withdrawal liability in the building trades. But if you go out of business and then come back in business within a 5-year period and you don't re-up your union contract, you will be assessed withdrawal liability. So that's the trigger point in the building trades. You withdraw from a pension plan or you go non-union within a 5-year window. Now there are other ways you can get hit with withdrawal liability besides a complete or full withdrawal. There are partial withdrawal rules. And those, again, get a little more complicated. For most of you guys, the only way you're going to get hit with partial is if you really, really shrink your business over a 5-year period. Complicated formula again. You've basically got to be down to about 30% of where you were over an average look-back period. But there's another part of that statute that kind of lurks and people overlook sometimes. And that is for those of you contractors that may have 2 lines of businesses. If you have like a fab shop and then you install out in the field, and you shut one of those businesses down. So say you shut your fab shop down, but you continue to install out in the field. That too is a trigger point for partial, not complete, partial. So you're still in the plan, think about this. You're still in the pension plan, you're still paying in for your construction arm of your business, but your fab shop shuts down. That too is partial. And the numbers are astronomical. We just had a fund meeting in one of the funds, and the withdrawal liability numbers are usually in the millions if you do get assessed. In most cases, they will bankrupt the company, especially if you're a bigger company. So that's basically the background of how withdrawal liability works. The question really is, what is the tie-in to right to work? How are two related? You've got a federal ERISA statute that governs pension plans. How does that dovetail with a state law dealing with right to work and union dues? Well, I think, again, Don touched on that earlier. If you've got a bargaining unit and everybody in that unit, all the members, tell the union to take a hike and they terminate their dues authorization cards, that union is not going to sit around and represent that union for free. They're not going to handle their grievances. They're not going to negotiate their contracts. They're going to do what? Walk away from that bargaining unit when the contract expires. There are rules when you can do it, but for sake of our discussion, when that contract expires, I pretty much can guarantee you that union is going to say, hey, there's no way we can do this for free. We're not going to represent those employees for free, and we're walking away. If you walk away, what just happened? The shop became a non-union shop. You have a complete withdrawal or partial if it's a 2-line of business issue, and our friend withdrawal liability starts looming. This is something that wasn't thought about in the state capitol when they adopted it. I don't think it was even on their radar screen, but at the end of the day, it's a huge risk factor that could develop, and this is why I said earlier that extending these contracts and minimizing the risk of members bailing out after the right to work grandfather period runs its course. That's why it's in the interest of both unions and employers. And employers, again, as Don pointed out, you do have certain federal rights to encourage members and allow union access to the workplace to pitch their wares. So the bottom line is that withdrawal liability was not something that was intended to be triggered, but as happens often with these laws, you get these unintended consequences, and it's a real issue. And again, this is why I think that it behooves all of you guys that still have contracts out. You've got about 5 weeks here to get those deals done and get in under that grandfather clause and at least dodge that bullet for time being. I know, again, this is a technical area, and I'm sure we'll have some questions on that later, so I don't want to bore you this morning with any additional technical details. But just remember that right to work can trigger withdrawal liability on both the permanent withdrawal, if the union walks away or disavows a bargaining unit, or a partial if a line of business shuts down or you shrink company down to a very, very small percentage of its prior self. One more item I want to touch on that's not related to withdrawal liability, but I think it's related to these contract negotiations. Some of the feedback we're getting from the field is that some of the contractors are asking for indemnification when they sign these extensions of these contracts. And for those of you that don't know what indemnification is, you all know bonding, right? You all know insurance. It's really a form of insurance. Somebody stands as a surety or binding company or an insurer and picks up a risk. And the idea with indemnification is that contractors would say, hey, union, if we do all this, you indemnify us, the contractor, if we should get sued by the man primarily. The problem, the legal problem with those kind of provisions is that under the statute, the new right to work statute, there are 4 entities that could possibly file an action, plus the attorney fees. I like the attorney fee line. You've got the state, obviously. That's sort of out of our control. I mean, the state will do what they will do. But there are 3 other entities. You got the employee. He has a right to sue the union or the employer, saying, hey, somehow you're violating my rights. You got the employer. He can sue the union or the employee, saying, hey, you guys are screwing around and violating the statute. And in order to be fair and balanced, they threw in the union. The union has a right of action under right to work in case the employer or a group of employees is screwing around with its rights. So you got employees, employers, and unions. So think about now the relationships. If the union was to indemnify or insure the employer against some kind of risk related to this, the typical risk is going to be from the employee. Now, on the federal side, and Don touched on this, the union has a duty of fair representation to that man. So he has to represent it, just like we lawyers have to represent clients, unions have to represent members. So now, the union is representing the member and insuring the employer against a claim by that member. There is no way in hell the union can meet its duty of fair representation to the member by insuring the guy that the member wants to file a claim against. That's a problem for the union. If it's the employer that has a claim and he wants to sue somebody and he looks to the union for insurance, especially if he wants to sue the union, now how the hell can the union insure the employer? The employer then has absolute immunity. They can do whatever the hell they want, and the union has to pick up the pieces and pick up the cost. So there's just no way the union can handle it. If it's the union insuring the employer against its own claim, it's got problems on 2 fronts. It's now violating its duty of fair representation to the member, and you got the conflict issue and the absolute immunity. So our view is, from a legal perspective, those kind of provisions are a big, big problem for unions. If the unions are going to step in and try to indemnify the employers. So again, the takeaway points here, before we get to well, Pat's got an update for you too, but the takeaway point is that we've got this withdrawal liability 300-pound gorilla in the background that was not intended to be there, but the new statute kind of put him in there. Some of you guys might be aware of the Pension Protection Act, which requires these pension funds to be funded on an expedited basis. That actually makes the problem even worse because it grows the withdrawal liability in the short term. So you got the withdrawal liability issue. We got this indemnification thing that I think is kind of a distraction, but it really ought to be at least addressed, head on if you're still in negotiations. But at the end of the day, as we point out in our handout, there are a number of reasons why unions and employers need to sit down and try to work this thing out before March 27th or 28th, and get those deals done. I think you're doing yourself a service. I think you guys, again, the highlights are in the handout. You're going to get some stability, you're going to have some predictability and productivity, and frankly, the entire union-employer relationship is built on goodwill. I think the more goodwill going forward, the better off you're going to be. We do have some sample language reopeners in the back of the book. Those are samples for discussion purposes. They certainly can be modified, and so it gives you kind of an overview of what we're looking at as these over the next couple of weeks as these contract negotiations take effect. So again, thank you, Patrick and CAM staff, for putting this on. Thank you guys for coming, and some people do anything for free breakfast, right? Thanks, guys.
Next speaker is Pat Devlin.
Thank you, Jim. You're going to have to bear with me. One of the big losses that this law has brought about is my voice. I woke up this morning and didn't have one, so I've been talking about right to work since it's been enacted. Just to touch on, basically, I'm going to give an overview of what it does mean to us in labor and what I think it does mean, because I think this law brings about such an unpredictability to this industry. And I want to read a quote here that rushing controversial bills through a lame duck session is a bad way to make public policy under the best of circumstances. Doing so on such important issues while the public is shut out of the debate every step of the way is illegal and shameful. And I say that because we have doubled back and got the opportunity to talk to a lot of our state reps and senators that voted for this bill, not knowing what it really meant. They, for the most part, or a lot of them, were not aware of the fact of the problems that it presents. And when you put it in the context of this is no different than me being a member of a country club and going in tomorrow and saying, I'm still going to be a member of that country club, I'm just not going to pay my dues. They can't believe that. But that's what this law has presented. So, I don't know, there's talks out there of this bill being repealed, as all of you know, and studied the bill. There was an appropriations attached to the bill, so it's referendum proof. We can't have another referendum out there to overturn it. So with that said, I want to at least build up to how close this industry came to a carve-out similar to the public sector, police and fire, and agricultural workers and that. We did, up until the night before the bill was passed, come very close as an industry, because I think a lot of people up in Lansing understood that we're a little more unique than most out of an organized arena. So we came very close, similar to what had happened in Indiana. They also were very close. In fact, there was 20 Republicans that had voted on an amendment to their right-to-work law to carve out the building trades. Unfortunately, they were outvoted. The amendment was voted down, and the building trades did not get that. And that was based on the fact that I think a lot of lawyers got involved with the exposure rate was still, would be increased with more exclusions or not. So we have enjoined, the building trades have enjoined in 2 different lawsuits filed this past month. One in state court, one in federal court. The one in state court is based on the Opens Meetings Act. We don't know where that's going to go. We got a favorable ruling on the fact of when the law was being passed, the state capitol was shut down. We got the same judge that ruled that that was illegal and the capitol needed to be opened back up to the public. On the federal level, the lawsuit touches on the fact of preemption. They feel that this law is far-reaching, is preempted by federal law. So anybody's guess where those are going, you know, if we're going to get the law overturned or not. I think, again, just based on what I see out there, what I personally see in talking to every labor leader that I represent here in this room, is again the unpredictability, and where I'm seeing right now, I think Don made a comment that everybody's got to be very careful, labor and our contractors out there. So there's an unpredictability, there's an unknown out there, and you know, unfortunately, like John said, there's going to be a lot of money made by lawyers and insurance companies in this whole thing, and you know, it's just what we've got to live with. You know, talking around the country, it's been very positive. We've seen very little drop-off of union participation. I mean, people belong to a union organization because they want to belong to it. And not to say that not all of us don't have those situations that they don't think they're ever getting their bang for their buck. I think it's something that will speak for itself. You know, I think everybody in this room that's elected to that position takes their jobs seriously, represents their memberships well. They work for good contractors. They know what being in an organized setting is all about, and it's definitely worth the price. You know, it goes on to our training and everything else that's out there that's provided and makes us different from that other side that is our competition. The bad thing, again, with this law is it's just another situation thrown in the mix when trying to stay competitive is so difficult these days. So that's another thing that I think we all have to figure out the best avenue how to get over. Now, I'm in negotiations right now trying to amend, similar to what John had talked about on the extensions. We have the national agreements out there, the NMA, the GPMA, and for the most part our PLAs, which right now they're either utilized on a job-to-job or a year-to-year basis. There's been some movement that we could get those extended out to be 5 to 10-year agreements. The PLAs are another tool we can use right now before March 27th that would have a built-in union security clause. So we can get those PLAs negotiated. That's what we're trying to do. My public sector negotiations are not really going that well. You know, there was a lot of asks, and you know, for various reasons. I've got public workers at Wayne County, Wayne State, and obviously the city of Detroit, and everybody knows what's going on down there. So, but the Wayne County situation came with all the debt that they're experiencing with a big ask on pensions and all the other stuff. So I don't think we'll probably be successful in negotiating a contract before the 27th, but we're at the table trying. Again, I want to congratulate and thank the relationship that we do have in this room with our contractor base. We were side by side up talking to the legislature for a couple of months, more than a couple of months, probably about 8 months. We knew this thing was coming, and we really acted as a partnership to beat this thing back. We had great relation, or not great relation, we had great discussions with the governor. We thought we had him there on a couple of occasions, but with the influence that the contractor base had out there, I want to commend those relationships, almost being victorious in this thing. So, pretty much, again, I would just warn our people out there to be careful. Proceed with caution, because it is an unpredictability. Those states, again, that have went through right to work have not seen any basic drop-off. My big concern out there is just the workplace environment and what this law could bring to. I don't think it, and I think with the leadership from both labor and the contractor side, I think we would be on top of that. Hopefully minimize anything that could come about to disrupt workplace harmony. So, with that said, I want to be brief because I know we have a Q&A here, and we'd like to get all the questions answered if we can do that. I want to thank Kevin, Pat, and the staff for putting this all together. I know it came about, it seemed to be simple, but you guys always do a great job. Thank you very much for your attention.
Let's not take a break. We got some really good questions here, and rather than take a break, I'd like to get right into the questions. First question for the panel is, given the fact that the trustees who manage the benefits are compensated for lost time by the general fund, which is funded by working dues, how and why can we be compelled to provide non-members benefits?
I mean, that's my daily wage. Yeah, I think it was said earlier too, but the contract is still in effect in the bargaining unit, even though that unit may have union and non-union members. That means the contract controls the fringe benefit contributions, pension, health, apprenticeship, and so forth. So as long as fringe benefit contributions are being made on behalf of the union and non-union members, those employees will be participants in the fringe benefit funds. And their participation is governed by RISA and not by right to work. So RISA mandates when money comes in on behalf of a man or a woman, he or she becomes a participant and is eligible for all the benefits offered by that plan when they meet the eligibility criteria. So the fact that the trustees may or may not have mileage or other expenses paid by dues is not what controls. It's the trust agreements, plan agreements, and RISA, and that's a federally mandated law. In fact, there's a case out there that prohibits discrimination between or on basis of union membership at the fringe fund level. You can do certain things at the local level, and now let members vote, now let members participate in meetings, but not at fringe level. Fringe levels are pretty much open to everybody that contributions come in.
Thank you. Next question. Mr. Scharg made the statement, if a new contractor signs after the March 28th date, they would be under right to work. What if the short form agreement binds them to a contract in effect prior?
This is all new law. We guess at some of it, but I don't think an agreement that is predated will make any change in this law. The question will be, when does the new employer sign a contract? Not when that contract, how long that contract has been in effect for somebody else, but when does that new employer sign a contract? And if that new employer signs a contract on April 1st, I believe that the employees of that new contractor can choose not to be union members. And the problem is, those three little words, and attorney fees. Because if you guess, whether you guess right or when you guess wrong, you could be, if you enforce a union security provision and the employees say, you shouldn't be doing it, I want my money, they go get an attorney and they'll sue the employer for taking out the money from the union dues. So you gotta be very careful.
Yeah, just one additional comment there. So after March 27th, the grandfather clause basically says any new agreement or contract or practice or understanding, any new renegotiated or extended, this would be a new agreement, I think, at least based on what we know so far. You know, these things are going to get vetted through the courts and whatnot, but at this stage, that type of a short form agreement or Me Too agreement looks like a new agreement under that grandfather clause. and right to work would apply to that employer.
Next question concerns withdrawal liability. If a contractor is part of an association, how could the union terminate the contractor's contract when the association has a POA and is considered a bargaining unit?
Well, maybe I didn't make it clear earlier. You can't just terminate union contracts in midstream. It's a little easier to do it in building trades than non-building trades. But there are rules when contracts can be terminated, and when they expire, it's pretty well-settled law. When a contract runs its course, the union can get out of that bargaining unit. There are other ways to do it earlier, but for sake of our discussion, when that contract expires, that's the opportunity for the union to take stock of that unit and say, are we going to keep representing this unit? And if a whole bunch of members bail out from that unit, then they have no incentive to stay with it. Or if they all bail out. So that's the decision unions are going to face as these contracts expire and after they run their course under the grandfather clause.
Let me add one thing to that. Because there's association units, and then there would be non-association member signatories. So those are people who say, I don't want to be a member of the association, I don't want to go to the association meetings, but I do want to sign off to the contract. And for those employers who are non-member signatories, at the end of the contract, the union could easily say, we don't want to represent your employees anymore. We don't want to have a contract with you anymore. Now, I think the answer for the employer, for the non-member signatory, then, would be to avoid the triggering of withdrawal liability, would then become a member of the association and give the association a power of attorney, so it's part of the bigger group and can't be picked off that way.
Okay, just one follow-up, Dan. So the only time a union can disclaim a bargaining unit is when the contract expires, is that right?
Basically, you can have elections. Depending on the contract bar rule and all that wonderful stuff.
Okay.
You could have an election before a contract expires, and with right to work, that could occur sooner than before. You might have some folks that bail out on the union and instigate an election. But there are rules here, and I think for this forum, I don't want to get too technical. The bottom line is certainly at the contract expiration, and perhaps even earlier, the unit could go non-union and withdrawal liability.
Let me just add to that. There is a section of the National Labor... There is a section of the National Labor Relations Act which is called Section 8F. And I think most of the labor contracts that are signed are 8F contracts, which means that there was never an election in the unit. The employers just signed contracts. That's a specific exception for the construction industry. You sign a contract and say, okay, now we're going to be union with no election. Because there was never an election, the employees, the union, or the employer, during the term of that contract, can ask for an election. And so you could have a midterm situation where the union loses its loses its representation in that unit in the middle of the contract, or solidifies it, either or, depending who wins the election.
Will new apprentices coming into our trade union have a choice to pay dues or not, even if we have the contract extended before right to work came into effect?
Well, apprenticeship is one area where the right to work law is particularly murky. The short answer is the apprentices' rights depend on what's the status of the contract. If there is a contract in place in that unit or that industry that has a valid union security clause in place, then they won't have a choice. They got to pay dues to stay in and work in that bargaining unit. If the contract or the grandfather clause or the grandfather period is run out, then they might have a choice. But because that apprentice is indentured to an apprenticeship program, and that program is run by a board of trustees, and that board in turn is governed by ERISA, which is a federal statute, there are some additional rules that come into play. And there's some additional pressures that, and whatnot, again, I don't want to get technical, but some additional pressures that the JTC, the apprenticeship board can impose in dealing with apprentices. But the short answer is it all depends on the status of the contract. If the contract is grandfathered, union security clause is in place, that apprentice and all other employees in that bargaining unit must pay dues as per the union security clause. If the contract's expired, then different rules come into effect. But then there's some practical aspects to apprentices, because unlike journeyman apprentices, you can do a lot of things in controlling apprentices. You set them to work. JTC has a right to move them around from one contractor to another. There are restrictions on employment of apprentices. Most can't work by themselves, can't work out of jurisdiction, and so forth. So there are a lot more controlling factors that come into play with apprentices, but hopefully I didn't overshadow the short answer, which is depends on the contract.
Okay, the next question is, who can ask to see an employee's union card after the law takes into effect, comes into effect?
Who can ask? Can you ask to see the employee's union card? So we're talking about probably the employer. Can the employer say to the employee, "Are you a member of the union? Are you paying dues?" The employer will generally, I'm not sure how each union handles it, but usually there's from my experience, sometimes the union sends over a list of its union members that deduct the dues from these individuals. If the employee, under the Right to Work Act, sends a letter to the union saying, stop my union dues, I think the union will have some type of implicit obligation to tell the union, stop deducting these dues from this employee, because you don't want to get sued by taking the dues when you know you shouldn't be having them. Can the employer say to the employees, show me your union cards? Might be able to. If the employer says, I'm not going to take any action against you whether you have a union card or not, I'm just asking so I know who to pay dues for, can probably do that.
Yeah, just one additional comment. If by card we mean the union dues authorization card, not the membership card, then the employer has a right to have access to that too. But in most cases, employers will rely, and as a practical matter, will rely on the unions representing to the employer who is and isn't a authorized dues-paying member. I think that's probably and most of you union guys here either have cards or provide them to the third-party administrators or your fringe funds so they know where to send dues and so forth. So over the years, there have been practical ways of dealing with what do we do with union dues authorization cards. But membership cards are something usually BAs check on job sites to make sure the guy's paid up.
Let me just add that litigation is very expensive. And if you have to pay someone else's attorney, it becomes more expensive. Nobody is going to do something just to jack some employee around and play with their union dues, because it's going to be too easy to be sued and have to pay attorney fees, your own attorney fees, and attorney fees to the employee's attorney. Just as an example, I was reading a case where this employee under the Fair Labor Standards Act sued her employer, who happened to be her best friend. She received $35,000 in back overtime and $95,000 in attorney fees. So there's no proportion to, or no relation to the amount collected and the amount of attorney fees that are put into a case. So it can be very expensive. So what was that show in the 80s or 90s? Hill Street Blues. Be careful out there. You got to be very careful, whether you're an employer or the union.
Hey Jim, I'd like to add on just a practical, on the job sites, under most collective bargaining agreements, it does have a built-in steward assigned to each job. If it's just a question whether they still have the right to check whether somebody is, and now under current law, you have the right to ask for a member that's in good standing or not. I don't see anything, as long as it's not intimidating, that couldn't still be done after the law becomes effective.
Okay, next question is, how effective would a standalone union security agreement be, or a standalone referral agreement that requires membership. Would either of these be an easy target?
John and I have discussed this question several times. Let's take the standalone union security provision first. Some of the union attorneys in town, maybe some of the management attorneys in town have been talking about having two separate agreements between the associations and the unions, or the employer and the union. One agreement would be just a union security provision that goes on for 10 years. The second agreement would be a regular contract, which would terminate after every 3 years and be renewable through negotiations. I am of the school where I don't believe that's going to work. There's a lot of technical reasons. I've researched, I've written opinion letters about that, but my opinion, it's not going to work. In terms of the second question, having a members-only referral agreement that requires membership, so that would be a members-only hiring hall. I don't believe you can have a members-only hiring hall. I think you can charge a fee for using a hiring hall, but you can't have a members-only hiring hall.
Yeah, I think that's always been my understanding, that whether somebody was a member or not, they had a right to use the hall, but the union had a right to charge them a fee for the referral service.
Right, especially in a exclusive hiring, where you the local or the union is the exclusive referring agency. But on the contract issue, what I said earlier in my presentation, there's nothing that we can tell you to make your future contracts absolutely 100% bulletproof. So the best advice that I can give you is negotiate a contract or an extension, do it before March 27th or 28th, and don't tinker with it, or minimize your tinkering. By that I mean, if you're going to do something to it, do a limited economic reopener, don't change language, because everything that you do over and above that, you run the risk of that action being an understanding or practice under this definition in the statute. So I think that's probably the safest. The dual contract thing is untested. Not only in Michigan, certainly, it's a new law, but Indiana, Oklahoma was before that, in 20-odd other states. There's not a lot of law out there that supports an absolute split in the contract, park a union security clause in one, and then deal and negotiate the other part. I think you run some risk more than you would if you do a contract now and then don't tinker with it. Tinker with it as little as you can possibly.
I want to add a footnote to that. From the employer's side, we would be concerned in a reopener of just limiting it to economics, because my definition of collective bargaining is that the employer bargains and the union collects. So when we get to situations of reopeners, I agree that they should be full reopeners, but an employer would want to try to target certain areas where it may want to have some language. Project in the future, we might want to have some language changes.
See, I said earlier, we're in agreement on right to work. This is one area where we're not in agreement.
Next question is, how does the right to work affect the national maintenance agreement?
Jim, I just touched on that. We are in negotiations right now with the National Maintenance Policy Committee on how we could.
Okay.
One quick comment on that. So a lot of you guys have contracts, direct contracts with locals, but then you work on NMA jobs, GPA jobs, PLAs. There's a question on Indian reservations. There's a question about federal enclaves like the Air Force Base. So it's like Swiss cheese. There are a lot of exceptions in that statute where the law may or may not apply. It's not clear in some areas. It's probably clear in others, but NMAs is one area that even though your local contract expires, but you're working at Marathon or DPS or whatever, that the obligation continues because some other agreement covers.
Okay, the next question is, if a contractor is awarded a project due to the union providing targeting funds, which are part of the member's dues, can the member that does not pay dues be prohibited from working on this project?
This really raises two questions. One is the targeting funds, and those are the union's own funds. They're not from the employer, they're not from the trust fund. So the union can, in my opinion, is the union can do what it wants with those funds. And if an employer comes before the union and has 50% of the employees or 20% of the employees not paying union dues, the union can decide, well, we'll skip this one. We'll look for somebody who's more deserving. That's one answer. The second answer, once those funds are given, nobody can dictate who works on the project and whether they're union members or not. If the contractor has people who are not paying union dues, or in the future would choose not to pay union dues, the union can't say, once it gets the money, can't say, you can't allow these people to work on the project.
Yeah, I mean, one clarification there is that a lot of your targeting funds are ongoing, so it's not a one-time deal. Sometimes they are, but, so there's a little bit of control, and this is one area where unions have some SWAT to deal with a employee that doesn't want to pay dues. Remember, the law does not prohibit discrimination, I'll put that in quotes, against a member internally within the union itself. So the non-paying member can be barred at the door. He does not get to go to a union meeting. He does not get to vote in elections, contract ratifications. If the union has like a mortuary fund or a flower fund or picnics, Christmas party, all those things you can bar that employee. Those are member-only benefits, unlike fringes. Remember, fringes, you have to let them in if they're paying in, but not inside the union. Targeting funds, again, if they are pure dues-sponsored funds, and the money comes from dues, it does not come through a joint trust of some sort, then you have some control. And one of the follow-up questions we had, another function is, gee, couldn't we target every job? Put a buck in this job, it's got to be modified targeting process. If you got a modified targeting job or targeted job, and you've got a mixed bag of employees, I think the union can, within its rights, control how it funds that job, and certainly have a lot of influence on who works on that job.
Our next question is, can non-members still use apprenticeship? Also, can they participate in various training classes provided by the union?
Well, the short answer is yes. So apprenticeship funds are, for the most part, they're ERISA-style funds. That means the contributions come in from a bargaining unit, quarter an hour, 50 cents an hour, whatever. And if the individual, union or non-union, meets the criteria for eligibility in that program or is already in that program, then you've got to cover them under ERISA. But again, the apprentices, as I said earlier, those boards that govern the apprenticeship funds, JATCs, have a lot of power, they have a lot of control over an apprentice, his work environment, his schooling, and his or her. As opposed to journeyman. So the short answer is yes, the apprentice is going to be treated like any other, the non-dues paying apprentice is going to be treated as any other dues paying apprentice because of ERISA. And because those are fringe benefits, they're not provided through dues. Now, if you have some kind of training, and maybe you do, have training paid through dues, then it's different. Anything paid through dues, if it's taxable dues funded benefit, normally we call them below the line. If it's below the line, not above the line, you can keep the non-union guy out. You don't have to provide, again, those the picnics, the bereavement funds, any training that you do within the union. But my experience is that most training runs through an ERISA jointly trusteed fund. That's the typical process.
Okay, Pat tells me we got time for 2 more questions. I find this one really interesting. If a member writes a letter to stop paying union dues, is it legal for the union to read the letter in front of the body during communications at a regular membership meeting?
In my opinion, as long as the union does not intimidate, coerce, or engage in any of the prohibited activities, the union has a right to publicize who is and who is not a union member. And if I were advising the union, I would specifically tell them to say to people, we're giving you this information, We're not telling you to engage in any harassment or intimidation, and we're telling you not to harass these people, but here's the information.
Right, and this goes to this whole idea of publicizing member or non-member lists. And there was kind of an open question whether you could publicize the bad boy non-member list, and that was resolved sort of back in December with a post office case, and they said basically you have a right to publish those lists. Now, having said that, I'm going to give you one of those lawyer answers. It depends on the intent. If you do that with the intent to intimidate or violate the right to work statute, then you might have an issue. But you do have a federal law, and this is an important takeaway point. The state right to work law did not change any of the federal labor laws. You still have all those wonderful federal labor laws in effect: organizing, picketing, dual gates, union elections, all that, ERISA, those are all still in effect. This just deals with one little aspect, although very important for the unions, deals with the dues, and inadvertently it also can drag in contractors through this pension issue and some of the other issues. But the bottom line is, yes, you can publicize, you can have stickers for the helmets, you can do all kinds of wonderful stuff, but it depends on your intent. If you have improper intent, you could have a right to work violation.
Okay, our last question is, who establishes the window of time for employees to revoke dues checkoff? And is there a required duration of the window?
The determination of when an employee can revoke dues checkoff and union membership is determined by both federal law and the unions.
Federal law, basically the rule is when the contract expires until there's a new contract signed, an employee can withdraw from the union. Under the checkoff, it has one period a year, an open period when the employee can resign from the union and stop the checkoff. The UAW, trying to be too clever by half, only has a 10-day period during the course of a year, like from the 10th to the 20th of a month, when the new moon is rising and something like that. That's been declared unlawful by the NLRB. Usually it's about a month period that an employee can choose to stop the checkup and end the union membership.
That concludes the time we've got.
One quick comment on that. So really this whole question of terminating a member's dues obligations is governed by two agreements: the collective bargaining agreement from the contractor perspective and the dues checkoff agreement. And that too is a contract. That's a contract between the union and the man or the woman member that says this is what your obligations are to the union. So you have to hit on both cylinders. As long as that valid dues checkoff card is in place, the contractor has a collective bargaining agreement that presumably has a valid union security clause requiring payment of dues. So again, you have to hit them on both of those. So there are some technical requirements, but Don already touched on those, and I think that's a critical point. A guy can't just walk up willy-nilly and say, "Gee, I want out."
That concludes our question and answer period. We're getting kicked out of here. I think everybody in the panel, if you've got a question that we didn't get to and you want to get an answer, I think you come up here after and we'll be here to answer those questions. But I want to thank Pat for putting this thing together. This was his idea, and he did a hell of a job.
Thank you, everybody. Thank you for staying on a little longer. I know we went a little longer than we were set to, but we do have a couple dozen more questions here. If you will leave your name badge maybe with your business card, I'd like to communicate back with you. If we can find some means of getting these questions, get a Q&A out to you, maybe our panelists would be willing to assist with that. Also, we have videotape, so keep on track of the CAM website. Hopefully we'll be able to get the technical together and make this available for those of you who would like to see it again or refer it out to some of your staffs and associates. Again, thank you for coming. Thank you again, distinguished panelists, Mr. Statham, Mr. Scharg, Mr. Tesija, and Mr. Devlin. Have a great day, everyone.